Welcome back to Good Law, Bad Law. My guest on today's episode is UCLA law professor Adam Winkler. He's the author of a new book called We the Corporations. And in this book, Professor Winkler traces the history of our Supreme Court's approach to the rights of corporations. Now, you might have thought that the Bill of Rights and other important rights defined by our courts apply to individuals, to human beings. But actually, the history of our Supreme Court and the law as it's developed in the United States is one that has recognized a corporation's rights far more frequently and far earlier than many people's individual liberties were recognized. So this is a fascinating conversation leading to the infamous Citizens United case by the Supreme Court. There's a lot of great stories that Professor Winkler will share with us on this episode so that we understand how it is that in our country, corporations are the ones that really seem to have the rights. Take a listen. I hope you'll enjoy this episode. Welcome back to Good Law, Bad Law. Today we are talking about corporations and the way that the courts and the law have treated corporations as people, really going back to the early days of our country, and how that has led to some of the most controversial decisions in the last decade, most importantly and most notably, the Citizens United case, which we're going to talk about in just a minute. But to do that, I want to welcome my guest, Adam Winkler. He is a law professor at UCLA, professor of constitutional law, and the author of a new book called We the Corporations, How American Businesses Won Their Civil Rights. So first of all, Adam, thanks so much for being on the program.
Thanks so much for having me. It's a real pleasure to be here.
I've really been enjoying reading the book. There's some really great stories here that help us understand the role of corporations in we already know, of course, the role that corporations have played in our economy, but I don't think most people have spent much time thinking about the role of corporations as the courts and as our law has defined them as people, as persons, and why that's important, and why that had led to a decision that I think probably most people have heard of. But let's start with that. Tell us a little bit about yourself and how you came to this book and how the Citizens United decision really becomes a launching point for a bigger exploration of the role of corporations in the law.
Well, terrific. Well, I'm a professor at UCLA Law School, and I've long been interested in the question of which rights should corporations have. Business corporations have been at the center of some of the most significant Supreme Court decisions of recent years. You mentioned Citizens United, which held that corporations have the same free speech right as individuals to spend their money to influence elections. It struck down a campaign finance law that limited corporate money in elections. In recent years, we've also seen cases like the Hobby Lobby case, where a corporation asserted that it had religious liberty under a federal statute, and thus was entitled to an exemption from an Obamacare requirement that large employers cover birth control for employees. And we've also seen this, by the way, in other recent high-profile issues, such as the baker who refused to bake a wedding cake for a same-sex couple, a case that was really about whether his business was obligated to provide those resources. And these cases brought public attention to the question of the rights of corporations. But I knew from my research that there was sort of a long hidden history of corporations seeking individual rights. And I wrote We the Corporations to tell that long story and to show that Citizens United, as controversial as it is, doesn't come out of left field, that there's a long history and tradition behind the Supreme Court giving corporations constitutional protections that belong ordinarily to individuals.
Now, in all three of those cases that you mentioned, the Citizens United, the Hobby Lobby case on birth control, and the Masterpiece Cake Shop case, all of those cases really had to first start with the premise that a corporation is a certain kind of a person, is a legal person under the law. I know there's more to it than that, a lot more to it than that, but that really has to be a first step in even considering how those corporations could even make a claim for those kinds of rights. Is that the basis or starting point for those decisions?
Well, in some ways, yes, and in some ways, no. I mean, first of all, we have to understand what does it mean to say that a corporation is a person. Now, obviously, it's not an existential claim that a corporation is exactly like you and me. If you prick it, it does not bleed.
Right.
A corporation is a person under the law in the sense that it is its own independent entity with its own rights and its own legal duties, wholly separate and apart from the legal duties and the legal rights of the people who form the corporation, the people who finance the corporation, or the people who work for the corporation. That's why if you slip and fall at Starbucks, you can't sue the individual shareholders. You can't sue Howard Schultz. You have to sue Starbucks, the corporation. Why is that? Because it's its own legal person with its own legal responsibility to keep its stores in working order and safe for customers. And so corporate personhood is really just the idea that a corporation has its own rights. And what's unique, and one of the surprising things I found in looking at the history of corporate rights, is that this idea of corporate personhood has played some role in expanding the rights of corporations. But not nearly as much as one might think. And in fact, the reason why the court has generally expanded the rights of corporations is that by ignoring corporate personhood, by saying that corporations have the same rights as their members, and that the reason we need to protect the rights of corporations is to protect the rights of the shareholders or the people who form the corporation. Again, that's exactly the opposite of corporate personhood. That is saying corporations are not their own people, but they are associations, and we should protect them for those reasons. So it's a slightly different approach. If you want me to give you a concrete example, think of the Hobby Lobby case. The court didn't say that Hobby Lobby as a corporation had religious freedom. It said that we needed to protect Hobby Lobby's religious freedom because we need to protect the Green family, the owners of Hobby Lobby, and their religious freedom. And that's a kind of pass-through thinking that lawyers who work in the business or corporate law area will recognize as being contrary to the way corporate law is run. Traditionally, the corporation is its own legal entity, its own legal person, and its rights are wholly distinct from the rights of its owners. In Hobby Lobby, the court said the exact opposite and said the corporation has the same rights as its owners.
Well, in the Citizens United case, though, seems a little bit different in that the Hobby Lobby case involves a business's obligation or not to provide certain benefits under a federal healthcare statute, the Affordable Care Act. But the Citizens United case is where you talk about the free speech rights under the First Amendment, and the finding that the government can't restrict the corporation's right to give money give money in an election campaign, and even in the final days of an election. That seems a little different because does the corporation need to have those rights when the owners of the company, whoever's behind Citizens United, or in the owners of a nonprofit company in that case, they can certainly give money to campaigns. Individuals can give money, and there's different requirements and limitations there. But the court, in expanding the rights of the corporation to actually have speech rights in that way, seems somewhat a very expanded role of seeing the corporation as a person.
Indeed, the court has expansively read the rights of corporations, and Citizens United certainly marks a high watermark for the rights of corporations. And in fact, 100 years ago, as I tell in the book, The Story and We the Corporations, when the first campaign finance laws were adopted 100 years ago, they were bans on corporate money in elections. And those laws were challenged 100 years ago by companies, mostly liquor companies, that were fighting against prohibition. And they wanted to spend money on elections so that we wouldn't outlaw alcohol. And they challenged these campaign finance laws in court and consistently lost. And courts back then, 100 years ago, said the electoral process is no place for corporations, that political speech is not the kind of right that a corporation is entitled to have. And Citizens United certainly goes the other way. And we've seen the court today give corporations more and expansive free speech rights than even more famously conservative courts like the Lochner Court of the early 20th century.
Well, we have to go. That's a great launching off point to go back in time because, as in your book, you tell some stories from the early days of the country and of our Supreme Court. So if we go back, we can then come forward again and understand it better. But it's fascinating to me that when you look at the way the framers in Philadelphia were were wrestling with the issues that ultimately go into the Constitution and into the Bill of Rights, as you describe it, they really gave almost no attention, no consideration whatsoever to the role of corporations in the law.
Well, that's right.
Yeah.
We go through the ratification debates, the Constitutional Convention. There was no discussion of whether corporations should have rights like individuals. And in fact, the framers harbored a certain hostility towards big corporations. The revolution was in part not just a revolution against the British government, but also a revolt against the most powerful corporation in the world at the time, the East India Company.
Mm-hmm.
And in fact, think about the Boston Tea Party. Well, the Boston Tea Party, what that was really about was the East India Company had become way too wealthy, way too powerful, and all the governments of Europe were heavily invested in that company. And when its fortune sagged in the early 1770s, it led to a huge bailout by the British government of the East India Company. And as part of that bailout, the East India Company gained the right to sell tea in the colonies for the first time without having to go through American colonial middlemen. And so the Boston Tea Party was an attack on the tea of the East India Company. They threw that company's tea overboard specifically as a protest against the new powers that this big corporation had. And so the framers harbored a certain hostility towards corporations. And even though they didn't intend the Constitution to protect the rights of corporations, it didn't take long for the Supreme Court to say that corporations were protected, just like individuals, by the Constitution.
Well, and we have to tell that story. And to do that, Adam, if it's okay, I want to take the liberty of sort of reading, because it's really startling to put this in context this way. Reading the first paragraph of what is chapter 2 in the book, and that'll set the stage for you to tell the story of that case. But as you write in the book in chapter 2, you say the Constitution of the United States went into effect in 1789, but it took nearly 70 years before the Supreme Court heard its first case explicitly addressing the constitutional rights of African Americans, and that was the Dred Scott case in 1857. The court in that case held that African Americans had, quote, no rights which the white man was bound to respect. And then you go on to note that the first women's rights case, Bradwell versus Illinois, on whether women had a right to practice law was not heard until 1873. And the Supreme Court ruled against the woman. In other words, that women could not practice law in the state of Illinois. And that was perfectly fine under the Constitution as of 1873. But conversely, the first corporate rights case that comes before the Supreme Court was decided as early as 1809, very, very early on in the history of our country. And in that case, the corporation won. So this was not, corporations were pressing for and winning their rights long before women and minorities, particularly African Americans in this country, were successful in seeing their rights vindicated in the Supreme Court. That's pretty incredible.
That's right. We think of the Supreme Court as a bulwark for the protection of the rights of minorities, especially vulnerable minorities and outcasts. But in fact, the court has over the years used its power of judicial review mostly to protect big and powerful corporations, even while it's ignoring the rights of women and African Americans. At least that was the story of the Supreme Court up until the 1950s, for sure. And one of the recipients of that generosity was the Bank of the United States, which was back in the founding era, was the biggest and most powerful corporation in America. It had branches all the way from Boston to New Orleans. We know the Bank of the United States is controversial because it led to the split among the founders over the Bank of the United States, led to the rise of the two competing political parties, along with a pretty good, memorable rap battle in Hamilton the musical, if you've seen it.
Right. Hamilton and Jefferson.
Right.
We'll explain that. Explain that, Adam, because that's really important also to issues that are going to come up later before the court on the role of the size of corporations and the role that corporations play. There was this tension very early on in the founding of our country, as you pointed out, fear of big corporations like the East India Tea Company. So how maybe have to set the scene a little bit and how Hamilton and Jefferson saw things differently on that.
Well, that's right. Hamilton and Jefferson really set the stage for sort of 200 years of debate over corporate rights in the Supreme Court. Jefferson was a populist who was opposed to big corporations and opposed the creation of the Bank of the United States, which was Hamilton's brainchild. Hamilton believed in the power of big corporations because he thought they provided wealth, stability, jobs, and a good financial footing for the new nation. And Hamilton, of course, won the debate over the Bank of the United States, and the Bank of the United States was formed. But Jeffersonians in Georgia tried to shut the bank down, tried by any means necessary, a little bit like today's opponents of Obamacare, like they'll do anything to stop this Bank of the United States. And they passed a law taxing the bank. And the bank said, wait, we don't want to pay that tax. And they took the case to the Supreme Court, saying they weren't going to pay that tax. And the case presented a question that seems kind of familiar to us today after Citizens United. Are corporations people? Or in this case, are corporations citizens under Article 3 of the Constitution that provides that citizens, when they're suing citizens of other states, can sue in federal court. And the corporation, the Bank of the United States, said, we have that right to sue in federal court too. We are like citizens. And the Supreme Court ruled in favor of the Bank of the United States and said that corporations were protected and did have the right to sue in federal court under Article 3. It's interesting to note, by the way, that that same provision of Article 3 was at issue in the Dred Scott case in 1857. And the Supreme Court notoriously said that African Americans could not be citizens under that very same provision of Article 3 that the court had a half century earlier said corporations could be protected by. So unlike racial minorities, corporations really did have rights the white man was bound to respect.
Well, it's fascinating that, in the founding of the country, there's this fear of big corporations. And again, refer to these giant export companies and the tea companies. And yet in 1809, there's a recognition that the biggest corporation in the United States at that time, this bank that Hamilton creates, has to be given the status of citizenship to protect its rights, the corporation's rights. Why and how does that change take place so quickly in a matter of a couple of decades?
Well, it's one of the really interesting things. One of the 1790s, the first decade of the United States under this new Constitution, was one that was marked by the rise of business corporations. At the founding, historians have figured out there were only about less than a dozen business corporations in the colonies. There were very, very few. It turns out that by 1800, there were over 300 business corporations in America. Americans used corporations for everything. And it turns out that they found that a corporation was a really helpful thing, something that people have found all the way back going all the way back to 300 years before the birth of Christ in Rome, when they first invented the corporation, was that a corporation is very useful because it enables people to pool their money together. And because it is a person, because it's its own entity with its own rights, it can hold that property and that money in perpetuity and use it to invest and create a lasting business. Unlike, say, a partnership. The partners still have the assets and it still belongs to the partners in their own names. And so a corporation was very different and provided a more lasting stability by being able to hold money. In the colonies, where there was a demand for a tremendous amount of infrastructure growth and stuff like that, but there wasn't very powerful governments to do it. There weren't kings with a lot of money to put money behind these things. Instead, they used the financing of the corporate form, allowing a lot of people to sort of crowdsource, if you will, the financing of businesses and infrastructure. And so Americans really took to the corporation quickly.
Well, and we forget too that we didn't have income tax at the founding, and for quite a long time after that. So government didn't have the resources to finance major infrastructure projects in the same way that the private sector could. So that also could be a basis for how corporations really start taking off in the early decades of the country.
That's right. There's tremendous economic demand. And then what happens is early on, one question is whether states retain extensive regulatory authority over corporations, or whether once a corporation is formed and the state has allowed the corporation to form, whether the state has to step back and no longer has the same kind of regulatory authority. This issue came before the Supreme Court in the early 1800s in a case argued by the legendary advocate Daniel Webster, who was famous for arguing more cases in the Supreme Court than just about anybody, more than 200 cases he argued in the early 1800s, and was very, very influential. And many of his cases were argued on behalf of big business and business corporations. And in one notable case that was brought on behalf of actually Dartmouth College, a corporation, not a business, he got the Supreme Court to say that corporations in general, whether business or not business corporations, but corporations in general, are private entities that are not subject to the same level of state regulation as, say, a state agency or a state organization. And so as a private entity, it was more like an individual with rights rather than like a state bound to respect our rights.
Well, how important are these early decisions? And again, we note that the Supreme Court recognizes these rights and recognizes a corporation's access to the court system long before they recognize the civil rights, the most fundamental civil rights of African Americans and women in this country. How important are these early decisions and the precedents that they set for the succeeding decades to the economic growth of the country? We know that the Industrial Revolution comes in the 19th century, and there's tremendous growth, expansion geographically, all of which sets the stage for the United States to become the power that it becomes in the 20th century. How important are these Supreme Court decisions to allowing the economy through business to grow in those ways?
Well, for instance, the Dartmouth College case that I just mentioned, where Daniel Webster won the right to call a corporation a private entity and thus not subject to the same kinds of state regulation that a state agency or public governmental agency would be subject to. That is, historians widely credit that decision as being really influential in promoting economic growth in the 1820s, 1830s, and 1840s, as the corporation became a reliable way to invest your money. If the court had ruled that the state could reorganize corporations at will, then perhaps people wouldn't have invested in corporations the way they did, because they would have been fearful that the government was going to come take their money one day. And so providing some protections for the rights of corporations, at least their property rights, their right to contract, their right to sue and be sued, really were essential for the economic growth of capitalism in America.
Well, how do we explain then because it seems like there's a steady growth in the recognition that corporations have rights until we get to the period of the trust busting era, at the turn of the 20th century. What's going on in the evolution of the role of the corporation and how the Supreme Court is regarding corporations in the broader economy that explains that moment and how things changed?
During the pre-Civil War era, the courts went back and forth a little bit. The Marshall Court was very expansive on the rights of business corporations, but the Taney Court was much more limited in its view on the rights of corporations. Taney was one of the first justices to call corporations, to say that corporations were people, legal persons, in a Supreme Court case. And he did it in a case that said that corporations were not entitled to the same rights as ordinary individuals. And And so the court was a little mixed in the pre-Civil War era. But after the Civil War, the court sort of really begins to side with corporations more and more. And as the rights of individuals expand, the rights of corporations expand too. And there's no greater or perhaps more disturbing example than one we'll talk about soon, I hope, about the 14th Amendment and how corporations won the rights of equal protection that were originally designed for the former slaves.
Yeah, that's a great story. That's and you talk about that in the very beginning of the book, is the case that Roscoe Conkling brings to the Supreme Court. That's a great story. Tell us about that.
Well, after the Civil War, Congress and the states passed the 14th Amendment to the Constitution, which provided that states shall not deny to persons equal protection of the laws. And this was designed to protect the rights of the newly freed slaves. But Roscoe Conkling, an illustrious lawyer for the Southern Pacific Railroad, went to the Supreme Court and argued that the 14th Amendment was also designed to protect the rights of business corporations. It was an audacious argument, but Conkling was unusually situated to make it. Conkling himself had been a leader of the Republican Party in Congress for 20 years, and he had not only himself been nominated to the United States Supreme Court and confirmed, a seat he turned down because he was making too much money as a lawyer for the railroads.
Yeah.
But early in his career, Conkling had been on the very drafting committee that had written the 14th Amendment. And he said that when we were writing the 14th Amendment, we were also intending to protect business corporations. It turns out that historians now know that Roscoe Conkling basically tried to defraud the Supreme Court, that he lied to the court, he misled the court about the history of the framing of the 14th Amendment, and that there's really no good evidence that the framers of the 14th Amendment ever considered the rights of business corporations when passing the 14th Amendment. But Roscoe Conkling, a lawyer who wouldn't allow a pesky thing like the truth to get in his way, nonetheless went to the Supreme Court and argued that corporations should have those rights. And the Supreme Court ultimately agreed. And in an astonishing fact I found, that in 1912, someone did a study of all the Supreme Court's 14th Amendment cases in the 44 years since it had been ratified in 1868. And the study found that there were only 28 cases in the Supreme Court on the 14th Amendment rights of African Americans. Yet during that same time, there had been 312 14th Amendment cases on the rights of business corporations.
Well, so what are
Roscoe Conkling?
Yeah, I mean, it completely.
Roscoe Conkling.
Yeah. Go ahead.
I was going to say, Roscoe Conkling and the Southern Pacific Railroad had transformed the 14th Amendment into a shield designed to protect the newly freed slaves into a sword used by business corporations to strike down business regulation.
So what were some of the rights that businesses were invoking the 14th Amendment to protect, or what types of regulations were they swatting away, invoking the 14th Amendment in that time period?
Well, in the Southern Pacific Railroad's cases, they were seeking to strike down a tax that was imposed on railroad property, but corporations used the rights of equal protection and due process under the 14th Amendment to strike out a whole variety of laws. And in fact, just a few years after the Supreme Court's rulings in the Southern Pacific Railroad cases, the court entered what became known as the Lochner era, roughly a period in the court's history from 1890 to 1937, where the court became famous, or notorious really, for reading the Constitution broadly to protect the rights of business and to limit government power to regulate businesses. And so using the 14th Amendment, corporations fought and got the Supreme Court to strike down maximum hour laws, minimum wage laws, certain zoning laws, some child labor laws even. So corporations sort of used the 14th Amendment. That was the springboard for launching any number of Supreme Court cases. And indeed, the court in the Lochner era, though it was notorious for being so business friendly, was confronted with so many claims by corporations for constitutional rights that the court, for the first time, adopted some clear boundaries to the rights of corporations, saying that corporations were entitled to property rights under the Constitution. The government couldn't seize their assets or their inventory or their buildings without paying just compensation. But at the same time, corporations were not entitled to liberty rights under the Constitution, those rights that were associated with personal autonomy, bodily integrity, and political freedom. And so the courts in the Lochner era turned away corporations that wanted to refuse to do business with unwanted customers, or turned away corporations that wanted to spend money on politics, saying that they don't have the same kind of political freedom that individuals have.
Well, that's a big distinction, the property rights of businesses versus their liberty rights. And again, that distinction and that limitation on corporate rights is what really is being eroded by some of the more recent decisions we started out talking about. But again, it does seem, as you look back through, and we're taking a very broad sweep of history here, but it does seem like there is this back and forth, um, uh, and how the court is looking at corporations between giving very expansive rights and looking to limit those rights. And again, after a period of time when corporations successfully sued for their rights and invoked the 14th Amendment to do so in many cases, then there does come a period of time when it seems like those early fears about the size and power of corporations that Jefferson talked about come to the fore again, and we see big companies, big steel companies being broken apart as being monopolies. So the court does seem to swing back and forth through time, and as it wrestles with the same issues that Hamilton and Jefferson were wrestling with at the beginning.
That's right. And sometimes the court seems to be wrestling with it in the same case. So, and going both different ways. So a good example of this is you mentioned the trust busting efforts. And one of the great stories in American corporate history is Teddy Roosevelt and his effort to break up the trusts in the early 1900s. The story is much more complicated, as I found out. One thing that was complicated was that Teddy Roosevelt won election in 1904 largely thanks to corporate contributions. His campaign was funded almost entirely by big corporate contributions, which led to a big scandal and the first campaign finance laws limiting corporate money in elections. So the famed trust buster had his hand in the corporate till. But he did try to break up some trusts, and one of the trusts that he tried to break up, the tobacco trust, he fought back in court and claimed constitutional rights. The corporation said, hey, if you're going to charge us with some crime like this, we're entitled to the protections that the Constitution offers to criminal defendants. And so when Roosevelt subpoenaed the company's officers to testify before the grand jury, the company said, you can't force our officers to testify. That's a violation of our Fifth Amendment right against self-incrimination to have our own officers testify against the company. And the Supreme Court in that case took the case and said that corporations do not have Fifth Amendment rights against self-incrimination. But the court said in that case they do have some rights of privacy under the Fourth Amendment and are protected against having to disclose all of their internal documents unless government has good reasons to take them.
Well, I have to ask at this point, because here we've talked about Fourth Amendment, Fifth Amendment, First Amendment rights, 14th Amendment rights, but the word corporation doesn't appear anywhere in the Constitution, as you point out. And the framers themselves gave barely any consideration to the rights of corporations in crafting the Constitution. So in a time where we know that there are many, particularly conservative constitutionalists, who point to the Constitution itself and the framers' intentions for understanding of how to interpret the Constitution. And those same people might be seen as tending to be more pro-business in their judicial outlook. How do we square that? How do we square all of these rights being found on the part of corporations when they didn't even exist, and didn't exist much in the minds of the framers themselves, and don't exist at all in the actual language of the Constitution?
It's really a great question, because over the years, originalists have really criticized those who believe in a living or evolving Constitution. Right. And that expansion of minority rights, of women's rights, of abortion rights, and gay marriage rights. Yet, if we look back through history, some of the biggest beneficiaries of the living Constitution have been business corporations.
Right.
But although corporations were not part of the original founding vision of who should have rights under the Constitution, the Supreme Court has broadly read the Constitution over and over again to protect the rights of business corporations. Even as I mentioned in the Bank of the United States case in 1809, saying that corporations were effectively citizens under the Constitution, when certainly it seems clear that they're not that. And so we have had this kind of living Constitution, and corporations have been the primary beneficiaries.
Yeah.
This has caused some problems for originalists like Justice Antonin Scalia, who wrote a separate concurring opinion in the Citizens United case to address this issue. And he said that as an originalist, he thought that corporations should have rights, in part for the same reason we talked about early on in the show, that the idea is not that corporations are people with rights of their own, but that a corporation is just an association of citizens. And that if we think of a corporation as just an association of citizens that has the exact same rights as its members, or asserts rights in order to protect the rights of its members, well, then you might see that, or might say that the only way to protect those fundamental rights that the framers imagined would be to apply them to corporations too. But it's a very difficult argument to make, and many people have criticized Justice Scalia's concurring opinion in that case for being less persuasive than some of his other more notable opinions.
Well, Adam, where do you see things going from here with those trio of cases that you mentioned, Citizens United, on campaign finance, and one that invokes the First Amendment rights of corporation, the Masterpiece Cake Shop case, also the First Amendment to the extent of the freedom of religious expression, and the Hobby Lobby case, also a religious expression case. Where do you see how has the pendulum shifted? What do those cases suggest about the future of our court, the Supreme Court, and how it's going to view corporate rights?
We are now currently in a period of great expansion of the rights of corporations. The Roberts Court has expanded the free speech rights of corporations to say that corporations have a right to political speech, a greater right than the courts had ever recognized before in Citizens United. The court had said in the Masterpiece Cake Shop that corporations have religious liberty rights too under the First Amendment. And we're seeing corporations, and we're seeing the court read other doctrines, such as the commercial speech doctrine, very broadly to protect the rights of businesses and corporations to advertise. And so we've seen in recent years corporations successfully use commercial speech doctrine to strike down laws requiring graphic warnings for cigarette labels, laws requiring public companies to reveal in their securities documents that they use conflict minerals, and numerous other restrictions on advertising of alcohol and gaming and tobacco. And indeed, there was one study that found that in federal courts, about half of all First Amendment cases brought today are brought by corporations and the business associations that represent corporations. And so we are seeing this area where not only existing rights are being used primarily by corporations like the First Amendment, but we're also seeing the court expand the rights of corporations to recognize rights that they had never been recognized to have before, such as religious freedom and the right to spend money on candidate elections.
Well, that is where do you see the tension coming about then? Are there areas that you can see where there might, even with this court, even with the Roberts Court and two new justices appointed to that court by this president, Justices Gorsuch and Kavanaugh, is there any area that you can see where the court might impose some limits, or is it that there really don't seem to be any limits at this point? Are there some areas where you think that even this court might not go, I guess?
I think the area that's going to be the most controversial in the future of corporate rights claims will be tied to gay rights and equal access to public
accommodations by LGBT people. I think this controversy involving the baker who refused to sell a wedding cake to a same-sex couple really provides a window into the cutting edge of corporate rights claims. Will corporations be required, as they always have been, to, or not always have been, but have been for the last 50 years, required to serve people without regards to irrelevant identity characteristics like race or sex, or in this case, same-sex marriage? Or will they be entitled to claim a religious right to refuse to do service with unwanted customers simply because those customers are LGBT or involved in a same-sex marriage? I think it's one of the great civil rights issues of our time. And I think the court is, we faced this issue before, back in the 1960s, when corporations and businesses filed lawsuits challenging the Civil Rights Act. And they said that they have constitutional rights to discriminate and not to have to provide equal access. And the courts rejected those claims universally back then. I fear that today's court is not going to reject those kinds of claims in the context of LGBT rights. And if so, we may face a future in which LGBT people find in many places of the country that they're subject to broad discrimination in the marketplace.
Well, that would really upend a half century or more of civil rights precedents in this country if that were to happen. And I think that would be quite terrible and would fly in the face, actually, of the direction you'd like to think the court was moving in with the Obergefell case, the same-sex marriage case. If the court were then to turn around and allow corporations to disregard civil rights laws, public accommodations laws, and all the precedents the court has set in those areas. So that'll be something we're going to have to watch very closely. Truly, the book tells a lot of the history that we've been talking about, only some of which we've been talking about, but it really does it in a very readable way. And I don't say that lightly. This is a really enjoyable book as well as a very informative book, and I've been enjoying it very much so. So we will put a link to the book so people can get it when we post this episode and when we post a description, as we often do. And so I'll encourage people to go ahead and get a copy of Adam Winkler's new book, We the Corporations, How American Businesses Won Their Civil Rights. Adam, a professor of constitutional law at UCLA in California, my home state. Adam, thank you so much for being on Good Law, Bad Law. This has been so fun and so great for you to do this.
Thanks so much for having me on. It's been a real pleasure.
Fantastic.